case briefs, and so much more. LSData's got what you're looking for.
In 1967, a legal dispute arose involving an oil and gasoline business that ended up reaching the United States Court of Appeals for the Fifth Circuit under the name United States v. Parker. Curtis L. Parker and his wife, founders of the business, were at odds with the IRS over taxes tied to their sale of property to the business they owned. The Parkers' company had 1,000 shares, with Curtis owning 800 shares through a property transfer, and his associate, B.K. Eaves, owning the rest in exchange for a cash payment. However, a wrench was thrown into their arrangement when a clause in the company's Articles of Incorporation was invoked, stating no shares could change hands without the corporation first being given a buyout option. Additionally, a stockholders' agreement between Parker and Eaves specified that if Eaves left his role, his shares would be bought by Curtis, making the price determination more complex. This became relevant when Curtis sold depreciable assets to the corporation, and the question arose concerning how the gain from this sale should be taxed. The stakes in this legal battle were high. The IRS held that Parker, holding an 80% share in the company, should be taxed at ordinary income rates on the gain from the sale instead of the lower capital gains rates, a point of contention which led to the court case. Eventually, the case reached the U.S. Court of Appeals for the Fifth Circuit. The lower court had ruled in favor of Parker, but the government appealed, arguing that Parker's ownership percentage qualified him for a higher tax rate. The appellate court, after careful consideration, decided to overturn the previous decision, agreeing with the government's argument. The court found that despite the restrictions on Eaves's shares, they were still adequately considered outstanding, pushing Parker's ownership percentage above the critical 80% threshold. As a result, the court ruled that the gain from the sale of the depreciable property would indeed be taxed at ordinary income rates under Section 1239, marking a victory for the government and a landmark decision in tax law.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.